Good afternoon, everyone. Welcome. Thank you so much for coming today. My name is Emily Keller. I'm the Interim Co-Associate Dean for Research and Learning Services here at the University of Washington Libraries. Let's take a moment to acknowledge and reflect on the lands on which we reside. Our University of Washington community is spread out around the globe. Would like to take the time to acknowledge all of the ancestral homelands and traditional territories of Indigenous peoples who have been here since time immemorial. The University of Washington acknowledges the Coast Salish peoples of this land, the land which touches the shared waters of all tribes and bands within the Duwamish, Puyallup, Suquamish, Tulalip, and Muckleshoot nations. We also acknowledge, with gratitude, this library's congressional designation in 1895 as a special place to collect, preserve, and provide access to official government documents, a federal depository library. We've collected over 1.5 million documents. Our librarians now assist users in finding their way through the .gov and .mil internet domains with resources numbering in the hundreds of millions of distinct URLs. So today we're going to read one of the founding documents of the United States, the Constitution, the foundation of which was written in Philadelphia over the course of 5 months in 1787. The document by design is meant to be amended to be kept alive by the people. Reading it at least annually is a good start. And now I'd like to introduce my dear colleague, Cass Hartnett, U.S. Documents Librarian and coordinator of this event for the last 20 years.
Thank you, everyone. I'm just so glad to be trying this in our new space, and we welcome your feedback on how you like this rather than the octagon in front of the grand reading room. I'm seeing friends and I'm seeing hugs and people greeting each other and introducing themselves to each other. So the weather may be a bit blustery, but we've got the Constitution and we've got our own voices. We would like to acknowledge today members of our armed services, active duty, and veterans in attendance today. If you would like to stand so that we may recognize your service in the defense of the Constitution. Now I will introduce our guest sitting in the front row. I will read everyone's introduction first, and then I've asked everyone to share how they came to take an oath to uphold. So Eric Flores is an archivist at the National Archives and Records Administration in Seattle and affiliate faculty at the University of Washington Textual and Digital Studies program, where he teaches archives, data, and databases. I'd like to take that class. A U.S. Army veteran, he served 7 years as a paralegal, assisting JAG officers with legal proceedings. He holds an MLIS and a graduate certificate in textual and digital studies from UW and is currently pursuing a Master of Legal Studies at Seattle University. Aaron Overby is a civil deputy prosecutor for King County, serving as general counsel to the King County Sheriff's Office. She is past president of the King County Bar Association, which is launching a program to provide attorneys and judges who will speak with community members on issues relating to the Constitution and rule of law. On Law Day this year, Aaron and the presiding judge prepared a program for attorneys to join them in renewing their oath as attorneys. This oath includes the promise to support the U.S. Constitution. More than 300 members of the bar joined in standing room only retaking of the attorney oath. Judge Laura Enveen, now retired, was appointed to King County Superior Court in July of 1992, unopposed for election throughout her tenure. She served for 27 years. She was presiding judge of the court, served as chief judge of the civil and juvenile departments, and was a member of the court's executive committee. She presided over all calendars of the court, adjudicating all types of cases. Earlier, she was a judge in King County District Court. Before that, she was in private practice, emphasizing municipal law and civil litigation. Her legal career began providing criminal defense in a public defender agency. Today, through the private firm, Hillier and Enveen Dispute Resolution, she still works, helping clients resolve their differences. She's past president of the Washington State Superior Court Judges Association. She received her undergraduate degree from the University of Puget Sound, where she's now a member of the Board of Trustees, and her JD right here from the UW School of Law. She has been honored with the UW Law Distinguished Alumna Award. So we're just so pleased to have the three of you. And why don't we go in the order I read? Eric and Aaron and Laura. Thank you.
Hello. So the first time I took the oath of office was in 2009 at the military entrance processing station in Sacramento. I was young, standing in a room full of other recruits as a soldier administered the oath to us. It was a formal, intimidating, and powerful proceeding. I was pledging my life to defend the Constitution of the United States. The second time I took the oath was in 2024 here in Seattle during my onboarding at the National Archives. This time, the ceremony was smaller, quieter, administered not by a soldier, but by an archivist. And even though that setting was different, it still felt profound. Both times, taking that oath felt incredibly literal to me. The first time meant defending the Constitution with my very life. The second time, it meant dedicating my work to preserving the actual artifact. As an archivist for the National Archives, I am now part of the institution that holds, protects, and safeguards that very record and the myriad of other records that embody the rights to the Constitution. I haven't yet had the privilege of administering the oath myself, but I hope to one day. It would be an honor to pass that moment forward to others. For me, the oath is more than just words on a page. It's a commitment to something larger than myself. It's a promise to serve the American people, whether in uniform or in the stacks of the National Archives. In both roles, I'm attempting to defend the same thing, the rights to history and the democratic foundation of this nation. Thank you.
Good afternoon. I was thinking about when I first took the oath, which was in the early 90s. So it's been a minute since I took the oath. And to be honest, when I first took it, it was the last barrier to practicing law. You have to take an oath before you can legally practice law in this state and almost every other state. So I was just looking forward to getting to the practice of law. And it was years later when I came back to the courtroom. Am I too close? Thank you. It was years later, I came back to the courtroom in the context of someone on the board for the King County Bar Association. And it was one of the favorite things that I ever got to do because it is a time when we welcome everyone into the practice of law. And it is really uplifting to see 50, 60, 70, 100 people plus coming in to take the oath of office for the very first time. The whole room is full of promise and we're launching them into their new career. Most recently, I took the oath. There was a little bit about that in the introduction. I took the oath again, and I have to say this time it really felt important. We, as lawyers, our job literally is to support and defend the Constitution. It's what we're supposed to be doing every day that we're practicing. And it was gratifying to see that on that day, more than 300 others of my colleagues, and those were just the people in the immediate range of the King County Courthouse downtown. We had others south in Kent. We had others in other parts of the state. We had people all over. And that's, to me, when we talk about our oath here in the state of Washington, we believe, I think this is a statement about not only who we are as lawyers, but what we believe. So we believe in the Constitution. We believe it's our job to uphold the Constitution. And sometimes that means you get an outcome you don't like. It happens to me all the time in my job. I get a decision from a judge I didn't really like or I don't agree with. But one of the other things that we agree to do in our state is we agree to respect and support the independence of the judicial branch. And I'm sure Judge Inby might have some thoughts about that. But we as a group of people, as a group of professionals, we understand the importance of the structure and the process that exists for all of us from the Constitution, whether you're talking about the separation of powers, whether you're talking about the rights reserved to our state, whether you're talking about how we protect your personal liberty under the Fourth Amendment. These are all such fundamental concepts. And so as we stood together in presiding court earlier this year, it was perhaps one of the best oath ceremonies I've ever attended. And I hope that all of you in coming here today are as interested in the Constitution as I am, because when I took this course in law school, I thought I'll never need that. I'll never use it. I've used it every day for over 30 years. So anyway, thank you for your interest in the Constitution, and I will turn it over to Judge Inby.
Thank you. I first took an oath to uphold the Constitution when I was administered, like Ms. Overby, the oath to be admitted into the Washington State Bar Association. Although I have the record for the longest ago oath, because that was 1979. I took it in Meany Hall, just across Red Square, with hundreds of other very excited new admittees to the bar. I was asked to reflect on what I was thinking and who administered it. For the life of me, I can't remember. All I know is, and all I remember is that I was so thrilled to become a member of the bar. Fast forward just about a little short of 10 years later, in 1988, I was administered the oath again. A similar oath, not exactly the same. And it was the oath to become a district court judge in King County District Court. And for those of you that are law nerds, there is actually a state statute that governs the exact wording of the oath and the requirement that the district court judges be administered that oath. And then just short 4 years later, I was administered a similar oath, but not exactly the same. And that was when I was appointed to the King County Superior Court by the governor of the state of Washington. And we, as elected officials and elected judges, we are, because we then have to run for re-election or retention of our position every 4 years, we are required to take the oath again. Although not as formally. With regards to my district court, and back then there were no cell phones, and so we don't have a lot of documentary evidence, but I brought a picture, and this was a picture, one picture that I have of me taking an oath, and that was in 1988 when I was administered the oath by now a federal district court judge, Marcia Peckman. This was in the old King County Council chambers, very small room, and with a few dignitaries and close friends. And I see that picture. I have that picture on a shelf in my house, and I reflect on how important that was. So I think that I've probably taken the oath 10 to 12 times, given that. And I have to admit, you know, I was in preparing for the remarks, we were asked to reflect on sort of the meaning of the oath. And frankly, I have to say that I really took it for granted, I think, in reflection over those many years, because I just presumed and I recognized how important the Constitution was, not even in my professional life, but even I remember a little bit of activism in my high school time. And just, it was just a given, the tenets of the Constitution. But Recently, I have to admit that upon reflection and really recognizing and thinking about those prior oaths, that I did take the concepts somewhat for granted. Recently, those tenets of the Constitution and the oath, the foundation upon which they are based, has been somewhat shattered. And I've really had to give more meaning and more thought to those concepts. It's really been close to my heart and of great concern. Recent threats to the judicial system, to judicial officers, and to attorneys, and frankly, the rule of law. And so when Ms. Overby referenced the recent oath that was administered this past, I think it was Law Day in May, in Washington State and throughout the nation, that oath I think was especially meaningful because it wasn't required to be taken. It was a group of members of the law, lawyers and judges who voluntarily wanted to reaffirm their commitment to the rule of law, their commitment to the Constitution. And frankly, I think that was probably the most meaningful oath when I reflect over the 46 some years of me taking an oath, to really think about that and reaffirm the importance and the concepts of the Constitution. I want to thank you for inviting me to be part of this, and I look forward to being one of the readers today.
I want to thank Eric and Aaron and Laura for sharing in this way. It was so thoughtful and thought-provoking. It just was very meaningful to hear from you, and I'm sure I'm speaking for many of us. So now we're going to go ahead and read the Constitution from the Articles of the Confederation to the rather unusual Amendment 27.
We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility,
provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen, or she.
Representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. This infamous 3/5 clause in the Constitution was eliminated in 1868 by the 14th Amendment.
The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made, the state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3.
When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their speaker and other officers, and shall have the sole power of impeachment.
Section 3, the Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof. There is an addendum to that. The 17th Amendment, adopted in 1913, changed this section of the Constitution to permit the direct election of senators. They're elected for 6 years, and each senator shall have 1 vote. Can you hear me? Immediately after, they shall be assembled in consequence of the first election. They shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the 2nd year, of the second class at the expiration of the 4th year, and of the 3rd class at the expiration of the 6th year, so that 1/3 may be chosen every 2nd year. And if vacancies happen by resignation or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. Again, there was the addendum that the 17th Amendment, adopted in 1913, changed that portion of the section of the Constitution to permit the direct election of senators.
No person shall be senator who shall not have attained the age of 30 years and been 9 years as a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice President of the United States shall be the President of the Senate that shall serve no vote, unless they be equally divided. The Senate shall choose their other officers and also a President pro tempore in the absence of the Vice President, or when he shall exercise the office of President of the United States.
The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgments in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law.
Section 4, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be on the first Monday in December, unless they shall by law appoint a different day. Asterisk note, the 20th Amendment adopted in 1933 changed the date on which Congress convenes to January 3rd.
Section 5. Each house shall be the judge of the elections, returns, and qualifications of its own members, and a majority of each shall constitute a quorum to do business. But a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner and under such penalties as each house may provide. Each house may determine the rules of its proceedings punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member.
Each house shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as may in their judgment require secrecy. And the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those present, be entered on the journal. Neither house during the session of Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting.
Article 1, Section 6. The senators and reps shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place.
No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office.
Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate shall, before it becomes a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it with his objections to that house in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of that house shall agree to pass the bill, it shall be sent, together with the objections, to the other house, by which it shall likewise be reconsidered, and if approved by 2/3 of that house, it shall become a law.
But in all such cases, the votes of both houses shall be determined by yeas and nays, and the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the president within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress, by their adjournment, prevent its return, in which case it shall not be a law.
Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the case of a bill.
Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states, and with the Indian tribes, to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States, to coin money, regulate the value thereof, and of foreign coin, and fix the standards of weights and measures, to provide for the punishment of counterfeiting the securities and current coin of the United States,
to establish post offices and post roads, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
To constitute tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations, to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water, to raise and support armies, but no appropriation of money to that use shall be for longer term than 2 years, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress.
To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by secession of particular states and the acceptance of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for the carrying into execution the foregoing powers, and all other powers invested by this Constitution in the government of the United States, or in any department or officer thereof.
Section 9. The migration or importation of such persons as any of the states now existing shall think proper to amend, shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. The privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. No bill of attainder or ex post facto law shall be passed. The following is in brackets. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. There is a star following this. The 16th Amendment, adopted in 1913, changed this clause of the Constitution to permit the federal income tax.
No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state.
Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress.
No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter in any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay.
Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector.
The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president, if such number be a majority of the whole number of electors appointed. And if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the president. But in choosing the president, the vote shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. Addendum. The 12th Amendment, adopted in 1804, changed the way the president and vice president are chosen under this section of Article 2.
The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States.
In the case of the removal of the president from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve upon the vice president. And the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president. and such officer shall act accordingly until the disability be removed or the president shall be elected. The 25th Amendment, adopted in 1967, altered the method of presidential succession described in this clause.
The president shall at stated times receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected. And he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States.
Section 2. The President shall be the Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject related to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment.
He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. The president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session.
Section 3. He shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed and shall commission all the officers of the United States.
Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors.
Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive their services a compensation which shall not be diminished during their continuance in office.
Section 2. The judicial power shall extend to all classes, in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under the grants of different states, and between a state or citizens thereof and foreign states, citizens or subjects. Note,
The 11th Amendment, adopted in 1795, changed this section of the Constitution to protect that states against lawsuits in federal courts by citizens of other states or a foreign nation.
In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed.
Section 3, treason against the United States shall consist only in levying war against them or adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted.
Article 4, Section 1. Full faith and credit shall be given to each state, to the public, in each state, to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe in the manner of which in which such acts, records, and proceedings shall be proved and the effect thereof.
Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime.
This is in brackets. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. There is an asterisk. The 13th Amendment, abolishing slavery, eliminated the fugitive slave clause from Article 4 of the Constitution.
Section 3. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state.
Section 4. The United States shall guarantee to every state in this union a republican form of government, and shall protect each one of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence.
Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states.
Or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate.
Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding.
The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States.
Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and the independence of the United States of America, the 12th in witness whereof we have hereunto subscribed our names, Governor, Washington, President, and Deputy from Virginia.
New Hampshire, John Langdon, Nicholas Gilman. Massachusetts, Nathaniel Gorham, Rufus King. Connecticut, William Samuel Johnson, Roger Sherman. New York, Alexander Hamilton. New Jersey, William Livingston, David Brearley, William Patterson, Jonathan Dayton. Pennsylvania, Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimmons, Gerald Ingersoll, James Wilson, and Gov. Morris.
Delaware, George Reed, Gunning Bedford June, John Dickinson, Richard Bassett, Jacob Broom. Maryland, James McHenry, Dan of St. Thomas Jennifer, Daniel Carey. Virginia, John Blair, James Madison Jr. North Carolina, William Blount. Richard Dobbs Spate, Hugh Williamson. South Carolina, Jay Rutledge, Charles Coatsworth Pinckney, Charles Pinckney, Pierce Butler. Georgia, William Few, Abraham Baldwin. The test, William Jackson, Secretary. Amendments to the Constitution of the United States. The preamble to the Bill of Rights, Congress of the United States, begun and held at the City of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states having, at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent and
of its institution.
Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring, that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, all or any of which articles, when ratified by 3/4 of the said legislatures, to be valid to all intents and purposes as part of the said Constitution.
Articles in addition to an amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of the several states pursuant to the 5th article of the original Constitution. Note, the 10 amendments were ratified. The first 10 amendments were ratified December 15th, 1791, and form what is known as the Bill of Rights.
Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances.
Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Amendment 3. No children shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger.
Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Amendment 7, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10.
The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people.
Amendment 11, Article 3, Section 2 of the Constitution was modified by the 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, by citizens or subjects of any foreign state.
Amendment 12, passed by the Congress December 9th, 1803, ratified June 15th, 1804. A portion of Article 2, Section 1 of the Constitution was superseded by the 12th Amendment. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for president, and in distinct ballots the person voted for as vice president, and they shall make distinct lists of all persons voted for as president and of all persons voted for as vice president, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate.
The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be president, if such number be a majority of the whole number of electors appointed. And if no person have such majority, then from the persons having the highest number not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice.
This is in brackets. And if the House of Representatives shall not choose a president, whenever the right of choice shall devolve upon them before the 4th day of March next following, then the vice president shall act as president, as in case of the death or other constitutional disability of the president.
The person having the greatest number of voices as vice president shall be vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for the purposes shall consist of 2/3 of the whole number of senators, and a majority of the whole number must be necessary to a choice. But no person constitutionally ineligible for the office of president shall be eligible for that of vice president of the United States.
Amendment 13, passed by Congress January 31st, 1865, ratified December 6th, 1865. Note, a portion of Article 4, Section 2 of the Constitution was superseded by the 13th Amendment. Section 1, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2, Congress shall have power to enforce this article by appropriate legislation.
Amendment 14, passed by Congress June 13th, 1866, ratified July 9th, 1868, Note, Article 1, Section 2 of the Constitution was modified by Section 2 of the 14th Amendment. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws.
Amendment 14, Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such states. The 26th Amendment lowered the voting age to 18.
Section 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability.
Section 4. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation occurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Section 5. The Congress shall have the power to enforce, by appropriate legislation, the provisions of this article.
Amendment 15, passed by Congress February 26, 1869, ratified February 3rd, 1870. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Section 2. The Congress shall have the power to enforce this article by appropriate legislation.
Amendment 16, passed by Congress July 2nd, 1909, ratified February 3rd, 1913. Note, Article 1, Section 9 of the Constitution was modified by the 16th Amendment. The Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration.
Amendment 17, passed by Congress May 13th, 1912, ratified April 8th, 1913. Note, Article 1, Section 3 of the Constitution was modified by the 17th Amendment. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years,
and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures.
When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution.
Amendment 18, passed by Congress December 18th, 1917, ratified January 16th, 1919, repealed by the 21st Amendment December 5th, 1933. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territories subject to the jurisdiction thereof for beverage purposes is hereby prohibited. Section 2. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states and provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress.
Amendment 19, passed by Congress June 4th, 1919, ratified August 18th, 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation.
Amendment 20, passed by Congress March 2nd, 1932, ratified January 23rd, 1933. Note, Article 1, Section 4 of the Constitution was modified by Section 2 of this amendment. In addition, a portion of the 12th Amendment was superseded by Section 3. Section 1. The terms of the President and the Vice President shall end at noon on the 20th day of January, and the terms of senators and representatives at noon on the 3rd day of January of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin.
Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day.
Section 3. If at the time fixed for the beginning of the term of the president-elect shall have died, the vice president-elect shall become president. If a president shall not have been chosen before the time fixed for the beginning of his term, or the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified. And the Congress may by law provide for the case wherein neither a president-elect nor a vice president shall have qualified, declaring who shall then act as president, as the manner in which one who is to act shall be selected, and such person shall act accordingly until a president or vice president shall have qualified.
Section 4. The Congress may by law provide for the case of the death of any of the persons for whom the House of Representatives may choose a president whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons for whom the Senate may choose a vice president whenever the right of choice shall have devolved upon them.
Section 5. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years of the date of its submission.
Amendment 21, passed by Congress February 20, 1933, ratified December 5, 1933. Section 1, the 18th article of amendment to the Constitution of the United States is hereby repealed. Section 2, the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. Section 3, this article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution within 7 years from the date of the submission thereof to the United States, to the states by the Congress.
Amendment 22, passed by Congress March 21st, 1947, ratified February 27th, 1951. Section 1, no person shall be elected to the office of the president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within which this article becomes operative from holding the office of president or acting as president during the remainder of such term.
Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress.
Amendment 23, passed by Congress June 16th, 1960, ratified March 19th, 1961. Section 1. The district constituting the seat of the government of the United States shall appoint in such manner as Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. Section 2, the Congress shall have power to enforce this article by appropriate legislation.
Amendment 24, passed by Congress August 27th, 1962, ratified January 23rd, 1964. Section 1, the right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. Section 2, the Congress shall have power to enforce this article by appropriate legislation.
Amendment 25, passed by Congress July 6th, 1965, ratified February 10th, 1967. Note, Article 2, Section 1 of the Constitution was affected by the 25th Amendment. Section 1. In case of the removal of the president from office or of his death or resignation, the vice president shall become president. Section 2. Whenever there is a vacancy in the office of the vice president, the president shall nominate a vice president who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3. Whenever the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president.
Section 4. Whenever the vice president and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the president pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the president is unable to discharge the powers and duties of his office, the vice president shall immediately assume the powers and duties of the office as acting president. Thereafter, when the president transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the vice president and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, transmit within 4 days to the president pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the president is unable to discharge the powers and duties of his office.
Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress, within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the president is unable to discharge the powers and duties of his office, the vice president shall continue to discharge the same as acting president. Otherwise, the president shall resume the powers and duties of his office.
Amendment 26, passed by Congress March 23rd, 1971, ratified July 1st, 1971. Note, the 14th Amendment, Section 2 of the Constitution was modified by Section 1 of the 26th Amendment. Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation.
Amendment 27, originally proposed September 25th, 1789, ratified May 7th, 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened.
Thank you for your wholehearted participation. We'll see you next year for the 21st annual reading of the U.S. Constitution.